It gives me immense pleasure to welcome Mr. Anurag Agarwal. He's the law clerk cum research associate with the Supreme Court of India, and he's going to share his personal insights with regard to the role of law clerk cum research associate with the Supreme Court of India. Without further ado, let's welcome him.
Hello, everyone. It's my pleasure to be here. As Ms. Das has already introduced me, but before going to the agenda for today's discussion, I would like to tell you that after graduating in 2019 from IPU Delhi, I appeared for this exam in 2021 and got selected, fortunately, in November 2021. And in the same year, I cleared the CLAD PG and I did my master's from this very university. And it's a pleasure for me to be here again. I would like to tell you about a brief about that how to get into this position. In addition to that, a detail about the perks and the challenges which one individual faces when he or she works as a law clerk cum research associate. So I got a call from the office of Honorable Mr. Justice Aniruddha Bose last year in November that you have been called for a brief interview and you have been selected by the sir after being on panel. And since November 24 last year, I have been working with him and still working with him. So I might not be able to share with you my some insights which are off record because I believe it might be a breach of certain legislations and my duties. Without further delay, I would like to share with you the key responsibilities of a law clerk. So our day began with attending regular court hearings of the honorable judge, where we have to make brief and short notes, not of all cases, but of peculiar cases wherein some arguments have taken place. And after completing that court proceedings, we have to attend his residential office, where the files for the next day are waiting for us because we have to make briefs of those files. Like today is Friday, and Tuesday's cause list is out, Wednesday's cause list is already out, and the files are there. So we have to make them. In addition to that, there is some miscellaneous work which will always be there. Miscellaneous work comprises of, but not limited to, doing some research work, which the honorable judge might give you, pertaining to some orders or judgments. In addition to that, he will expect from you to do some due diligence of the daily orders. And apart from that, some miscellaneous chores of the office. And the most interesting aspect of this job is when you will be, asked by the honorable judge to, accompany him to the court. He's about to reserve some case for a judgment. We call it a CAV matter. So I was very much fortunate to join him at a very, relevant point of time. And the reason for the same is I will, just tell you in a short while. So why one should join it? So the first and the foremost thing which differentiate this office of an honorable judge than the office of an advocate or even that of a corporate firm is that you will get to see only a specific kind of case. I remember that when I was working with the Standing Council of ED and CBI last year, so I got to see only that ED CBI matters. Apart from that, if you work, so again, there will be either tax matter or IPR matters or trademark and something like that. But I was amazed to see a diverse, set of cases when I was working with the honorable judge, because under one roof, you just name it. You will get to see election dispute, service matter, civil property matter, partition matter, matrimonial disputes, bail matters, criminal matters, writ petitions, habeas corpus petitions, you say, what else, constitutional matters, and even your tax matters, insurance matters. So apart from that in-depth legal knowledge, what one get to learn is in the office is the professionalism. Because see, you are working in the topmost court of India and with the honorable judge. So he or she will expect from you to, work with due diligence without any iota of error. Because I still remember that whenever a judgment is reserved for pronouncement, And when it is drafted, so the honorable judge expects us that there should not be any error even of a full stop or even of a comma, because there is no scope for any correction thereafter, being the Supreme Court of India. So we have to be very careful, and with this the professionalism is there, and along with that, time management. Why? Because if a judgment is given to you to research and to prepare its brief, so he will expect from you in a time bound manner that you should be done with your required research on the topic. Like I remember that in whenever slum dwellers case is there before the court, it is obviously a batch matter. So the Olga Tellis case will always be there. Similarly, whenever there is a land acquisition matter, so that Indore municipality case will always be there. So in this way, what a law clerk learns in the esteemed office is, I can say, it is much beyond anything for a person to with a legal acumen at such a young age. As I have already told you, that we got to see a diverse, a plethora of matters, diverse. So now it is like that the sections are very common for us. That if we know that, okay, if there is a bail matter, so what the court will ask, why you need him in custody, and the other party, that why you want that person to be out. And similarly, have you read CPC? CPC, not yet. Okay. So there is a section 25 under it, wherein if a party wants to get his or her case transferred to some other court, then you have to apply to the Supreme Court under section 25 of CPC. So we got to see those petitions also, but primarily they are of matrimonial matters. Like say if a husband has filed for divorce in say Hyderabad, so the wife who is living in Delhi will file a petition under 25 to get it transferred to Delhi. So in this manner, the transfer petitions are filed. So again, what I have deciphered is that there the ground should be clear, that if a wife is coming before the court, she should be aware that, okay, whether she is earning or not, whether she is having a child or not, and whether she is having her parents with her or not, and also the distance between the transferor court and the transferee court. These are the things which matters the most. So in this way, when you are working, because you attend the court not from the viewpoint of an advocate or from the viewpoint of a judge, you are just sitting there as a neutral person in between the two. So that is the most ideal situation for any young legal person to get this much knowledge in such a short span of time. Like now I have draft petitions with me. Tomorrow I want to practice in Supreme Court. So I will be aware that, okay, the bail matter is for murder, whatever. These cases are the ones which will, safeguard my client. And these are the ones which I have to oppose. Similarly, if there is, say, property dispute, say partition matter is there or a probation matter is there. So all these, without going into technicalities, what I'm trying to say is that you will get to learn a lot, not only practical but theoretical as well. So though I worked with him on almost all the judgments which he reserved for pronouncement, but some of the prominent judgments are there. The first one is the Jallikattu judgment. It was pronounced this year in May, and the hearings were concluded, I guess, till 8th December last year. So I was very fortunate because in some, a few initial days of my joining, that was the first case and a constitution bench matter, because he is the author of this judgment. So while I was working, so there were around 15, 16 writ petitions. Entire table like this was piled up with the files of only one case. The documents were there, counter affidavit, rejoinder, affidavit, all sort of, convenience compilation. So in this way, this was my first breakthrough in his office. So I will cover three elements which this judgment has dealt with. So the first thing is the pain element. It was argued by the petitioners, primarily PETA and FIAPO, that the bovine sports, be it Jallikattu in Tamil Nadu or bullock cart race in Maharashtra, or be it Kambala in Karnataka, primarily these three were before the court. So these bovine sports, they cause unnecessary, pain or suffering to the animals involved therein. And how they were able to prove is through their reports, investigation reports by PETA. that see, look, the bulls' tails are being twisted, red chilies are being used in their eyes, they are being, subjected to alcohol, drugs, all sort of things were there. However, what the court held by distinguishing here that under the Prevention of Cruelty to Animals Act 1960, there is Section 11. It lays down a list of all the activities which are, permissible. And the first clause is that if the pain is unnecessary, that activity is permitted. Meaning thereby that if the pain is necessary, inevitable, and this has been recorded by the court also, that in these sports, pain is there, we are not denying it. But what has been done by these three state laws is that that pain, unnecessary element has been watered down. So in this way, the court distinguished from necessary pain and unnecessary pain. Because today we use animals for farming, we use for transportation, like you can see in this picture, a man is using whip. So here also a element of pain is involved on the horse. We use animals for food. It is permitted. So why can't we use animals for these sports? Because one more reason was that the breed of bulls which are used for these sports is the native breeds. They are not hybrid or foreign breeds of the bulls. They are the native breeds, and it is to incentivize the farmers of these states to increase the population of such bulls. Otherwise, they are not very much economically, financially advantageous for the farmers because they have hybrid bulls. So in this manner, these sports are trying to protect the native breeds of bull. Second element was, which was also raised in the 2014 judgment of A. Nagaraja, which has been overruled in this judgment. In this case, what was held that there is a difference between animals and humans, because even I would like to pause, because I would like to tell you that on this aspect I have some conflict of opinion with the honorable judge. I said, sir, PETA has shown the reports, everything is before us, so why can't we declare these laws as unconstitutional? They are causing pain, they are not part of culture, they are animals which have been declared as humans in the previous judgment. So what is the point of keeping these laws alive? So the honorable judge reasoned his reasoning on two counts. First, jurisprudence. I guess, have you read that jurisprudence? So he cited two jurists. First was Hoffeld and second was Salmond. In Hoffeld analysis, he says that, Anurag, see, that if we are conferring right upon something, then that something has also an obligation, corresponding duty. But in this case, animals have no duty towards humans. So therefore, we cannot say that animals have fundamental rights. And the second element was from Salmond's jurisprudence, because Salmond has completely denied that animals have any sort of fundamental or even statutory rights. Because Salmond says that animals are animals, they are not humans. And here the fallacy was created by the petitioner side that person word which is used in Article 21 includes animals, non-humans. However, that is not the case here. Person means foreigner and citizens of India. It never intends to include animals. Because if you go back to the Constituent Assembly debates, there you will find that what is the meaning of the word person. Apart from that, the third element was that these sports do not form the part of culture or tradition under Article 29. So therefore, these sports should be declared unconstitutional. There was a seal. So that was showing that Jallikattu was prevalent centuries ago as well. And also in these three state laws, it has been declared that these sports, being a part of culture or tradition of the respective states, will continue. So the court has not questioned on the legislative intent of the states that whether they are the part of culture or tradition or not. Here, I would like to differ on this aspect from the honorable judge, because what I personally believe is that the court ought to examine the legislative intent. Because if legislature will do whatever it want to do, because it has overturned the previous judgment. So what counter I received from the honorable judge was, have to maintain the sanctity of legislature as well, because these three state laws have also received the presidential assent. People, if the will of the people is in favor of declaring these laws or rather these bovine sports as a part of cultural tradition, So what's wrong in that aspect? So the court does not delve much into this area and very well upheld all the three state laws. One interesting fact was regarding the presidential assent. I remember that when I was in court, and this question was not raised, was not referred to the court, that whether the presidential assent was informed or not, because the president has to give her assent after going through some relevant material, documents, etc. So SG Tushar was there. He handed over some documents to the court, and they were sealed in the court itself. My value addition to this was that I had to go through a plethora of documents. I have to keep this thing in mind because my brief was equivalent to this judgment. 60, 70 pages. My brief was that much lengthy, which I prepared for the judge. The second judgment is on Juvenile Justice Act 2015. Very interesting. This Narayan Chetanram Chaudhary, this man, he along with two other individuals committed murder of 7 people in 1990, out of which 5 were women, 2 were children, and 1 woman was pregnant for the purpose of committing robbery. Trial court convicted him to death. In 1999, High Court confirmed it, and Supreme Court dismissed the review in 2000, and his death sentence was affirmed. So what happened that one fine day in 2019, he got a certificate, his birth certificate from his school headmaster. And on that basis, he filed a writ petition under Article 32. He said, Your Lordship, I was a juvenile at the time when I committed the offense. So on that count, I should be released. So what the court did, it dismissed that petition in limine with a direction to the inquiring judge, to the session judge of Pune, that we are appointing you inquire into this aspect as to whether he was a juvenile or not. And very interestingly, the inquiring judge came to the conclusion that yes, he was a juvenile. The evidence he produced was his birth certificate from his headmaster. Now here, what the state argued that, Your Lordship, because of paucity of time, we failed to cross-verify the documents, and still they were countering that part that he was not a juvenile on the basis of his attendance register. Here, in that attendance register, his name appears as Nirana Ram. So he pleaded before the court that because in Pune, the people find it difficult to pronounce my name Nirana Ram, so they chose to call me as Narayan. Chetan Ram is his father's name, and Narayan was his name. So the court said, very well, okay, you are Nirana Ram, because the state failed to prove that there was any person called Narayan in his attendance register. And here it is section 9 of the Juvenile Justice Act, wherein it is provided that if a person intends to claim juvenility, so that person can raise that plea at any stage of the case. Even after he or she has been convicted by the top court of the land, still he or she will get the benefit if they are able to make out a case. So in this case, he filed this section 9 along with 32. And inquiring judge came to the conclusion that very well, you were a minor. The state failed to counter it substantially. And the court noted that in order to maintain the balance of interest, a person who is in incarceration for more than 20 years, how he or she will be able to produce his documents in that efficient manner in which the state ought to have done. And on that ground, he was granted the benefit, and he has been released this year. But here I, again countered the honorable judge. So my point was that, sir, he is raising this at such a belated stage in 2019, after 19 years. So that guy is playing with the law. He is doing the abuse of process of law. How can you raise the belated claim of juvenility at such a delayed stage? So honorable judge said that, see, the purpose to impose a punishment, it is a welfare section provision. It is for the benefit of those individuals who at the time of commission of offense, they were actually minors. Because if you go by the records, so majority of these people who are convicted for such heinous and gruesome offense of rape, murder, dacoity, robbery, etc., they belong to very poor families. They are illiterate, and because of that, they are unable to hire an advocate, a good advocate services. So many a times it happens, and therefore we cannot deny the benefit of justice to an individual on the technicalities of law. So here it was held that okay, being a welfare provision, the benefit is granted to this person. He is able to satisfy or prove his case, and in this manner, this person was released. Now, the second thing is regarding the nature of offense. But I hope that I have already covered this conflict, that nature of offense does play a role. But if we go by the broader, picture, so the purpose of this provision has to be seen in toto. One cannot ignore the purposive interpretation of a law. Moving ahead, the third case. It is of maternity benefit. And here in this case, what the court held was that if a woman is on contract and she claimed maternity benefit, she is receiving it, but her contractual period expires. But as per the act, she is still entitled to receive the benefits. So a notional fiction is created by the court, and the court held that she will be entitled to the benefits even after her contract has terminated, meaning thereby that the Maternity Benefit Act, the purposive interpretation was again done. And the level of, the legal acumen with which the Honorable Judge came to this conclusion was very well appreciated across the corridors of the Honorable Court. That such a welfare, legislation has been given such a wider interpretation. So on three counts, I would like to explain this. The first is welfare. As I have already mentioned, that the purpose has to be seen, because see, you as a law student must know that why this particular provision is there. What is its relevance? What good or bad is it doing? If a provision is there, then what is the purpose of proviso attached to it or exception? So one must always have that, intriguing intellect, that I want to know that why is this here? What is the purpose it is serving? What good or bad is it doing? So in this manner, if you will read the law, so you will not only you will not be required to then cram the things. You will automatically get them in your memory, and in this way you will rise to the heights in this legal profession. Second count is section 12(2). Because under section 5 of this act, the requirements of claiming the benefit is provided that if a woman has worked for 80 days in the preceding year of her delivery, then she is entitled to the benefits of the act. So what the section 12(2) says is that if a woman is discharged or if she is dismissed from her service, then it imposes an embargo upon the employer that he will continue to grant her the benefit. So here what the court did, it purposefully interpret the term discharge. That discharge means on termination or on culmination of the contractual period. So if a discharge is there of a woman, if she absents herself from work because her contract has completed, it will impose an embargo upon the employer that you have to provide her the benefits till the act allows. And the third, Indian contract, it is related to Indian Contract Act. I hope that you must have read. So it is related to that. It is section 27, that is a non-obstante clause, an overriding provision. It says that if there is an agreement and if it is in conflict with the Maternity Benefit Act, then this act will have the overriding effect over that particular conflicting provision. So if you have entered into a contract or agreement of service which is against the purpose of the act, so that contract or agreement will be void ab initio. It will not be valid for any purpose. So on these three counts, the court purposefully interpret this judgment. And this is the fourth and the last for today. That is recently pronounced Paul Rubber Industries. So first of all, before dwelling on the facts of this case, I would like to give you a brief of the TPA and Registration Act. So here, Section 105 of TPA provides for lease, that if a person has entered into a rent agreement or a lease with another person, so a lease comes into force. Then there is next, that is 106. It says that if there is no contract between the parties, and if the lease was for agricultural purpose or manufacturing purpose, so it can be terminated by a 6 months notice. It will be deemed to be year to year lease. And if that lease was for any other purpose, it will be deemed to be a lease for month to month, terminable by 15 days notice. So distinction is clear. Then next is 107 of the TPA. It says that how lease are made. So if a lease is of more than 1 year, so it requires compulsory registration. It is in line with the Registration Act, that is Section 49. What does Section 49 of the Registration Act says that, here your Evidence Act will come into picture, that if a document which requires compulsory registration has not been registered, it will not be admitted into evidence for any purpose, except collateral purpose. So here, what does the meaning of collateral purpose? Collateral purpose basically means that if a transaction was entered into for lease, so it is the main part of the transaction. Apart from the main element of the transaction, you can use that document for any other purpose. Let me explain by giving an example. Suppose A and B are lessor and lessee. The term of lease has concluded, and now the lessor comes to the court that please evict it, this man B. A files another suit. He claims that B was a trespasser. He is in wrongful possession of this property. Please pass the decree for recovery of possession and mean profits. So these two suits are filed. Obviously, if the document is not registered, which requires registration, so that cannot be used in first situation, but the collateral purpose is in second situation, the second suit. There the B can raise the plea that your lordship, this document though was not registered, but this document shows that I was in lawful possession for the time period of the lease. I was not in wrongful possession since inception. Only after the term is completed, then that a person can say that I was in wrongful possession, not before that. So here the court distinguished between the main purpose and the collateral purpose. Because here we have distinguished from Sivok Properties case. It was by Justice Chandrachud that collateral purpose means that you can use the instrument for examining the nature and character of possession of the person. But however, what honorable judge in this case held, that the nature and character of possession, it will be determined from the nature of the dispute, because in this matter the lessee fails to prove the manufacturing purpose, so it was deemed to be a lease for month to month, terminable by 15 days notice, and against which he approached the Supreme Court. So the court held that in this matter the nature and character of possession was the main element of lease between the parties. We cannot lay down a straitjacket formula that collateral purpose will amount to nature and character of possession in on all the cases. It will depend upon the facts and circumstance of every case, that whether this aspect is forming the main element of the transaction or not. And if it is not forming, then we can accept it. If it is not, then we will reject it. So in this manner, the honorable judge concluded and said that you failed to prove manufacturing purpose. Collateral purpose is also beyond your boundaries, so you are evicted. So any one of you interested in practicing in Supreme Court later on? So the main the manner of, I would suggest you that the exam of this law clerkship, whenever it will be there, like it happened this year in May, so either the exam is there for this law clerkship or some legal connection. But thankfully I was through this exam only. So I'm still on the panel um, and working with the honorable judge. See, honestly, this is a life turning experience for any young person like you all. I have discussed with you the perks because salary is also very handsome. Apart from the other benefits which a permanent government employee gets, the salary is equivalent to them. The challenges involved therein are regarding time, because it being a contractual job can expect you to work on all 7 days. Might you might get a weekly off, and you might have to work more than 12 hours some days. So things like that. But engaging with an honorable Supreme Court judge and discussing with him your ideas, your opinion, because he directly says, the honorable judge, you don't say yes, yes, you counter my point. So then it becomes like a court arena. So a very wonderful experience, a very great, amazing, life-turning experience you will get if you work in this position at such a young age. So with this, I would like to conclude. Thank you very much. If any one of you have questions, you are free to ask. Yes. Uh, at my time in 21, we did not get that opportunity to choose the judge. But this year, when the exam was conducted, so the opportunity is being given to the candidates. Yes, three references you can give. Like at my time, there was one exam in April 21. It was conducted objective type, and then interview was taken by three honorable. So they selected. Even after that, uh, individual judge will also take your interview before selecting you for his or her office. But now from this year, they have uh, divided it into two stages. That first will be your objective, and then along with the objective will be your subjective, wherein you will have to make brief. They will give you the facts. You have to make brief of that, like brief facts, impugn judgment, what is the question of law involved, and the grounds. Thereafter, you will have to shortlist that, okay, I would like to work with so and so judge. So then the individual judge will interview you, and then he or she will select you. But at my time, there were two interviews, sort of two. At first, the three are taking, and then the one is also taking. And one more thing is that, say if the slot with the judges is full, so there is one research wing of Supreme Court. So they will allot you there. That is in the research wing. So there the timing are like office hours from 10 to 5, flexible. But when you are attached with an honorable judge, so you will have to work as per him or her. Yeah. Yes, so I will tell you the functioning. Like Monday and Friday, they are the miscellaneous days of Supreme Court, where the fresh matters are filed. So the matters can went up to 50, 60, 70 on these 2 days. And on the other 3 days is the regular hearing matters. Meaning thereby, let's see if you have filed a matter, an SLP, and if the court has issued notice to the respondent appears, the court thinks that it is a fit case for giving a hearing, for giving a short. So then that SLP will be converted into an appeal. So then from petitioner you will be appellant, and then they are called as regular hearing matters. So their hearing takes on Tuesday, Wednesday, Thursday, and on Monday, Friday, fresh matters. So Monday, Friday, for them you will have a load before Monday, that is Saturday and Friday, because you have to finish them for Monday. And for Friday, you will have a load on Wednesday and Thursday. That is how the court and the law club functions. Some interesting matters. Recently, I worked on this Ashna Roy's case, a 2 crore claim for hair cutting of a model. So NCDRC awarded 2 crore as compensation. ITC came in appeal. So that was before us, but now it has shifted to some other bench. Apart from that, there was some other matter of like Hemant Soren recently. Like ED issues, it had issued summons against him. So and that Stalin's matter, that's Nathan Dharm, his comment. So petitions are now being filed. So you will get to learn a lot, different variety of cases. And this is how Supreme Court works. These are some insights from Law Clerk. Okay.
You can have some water.
Yeah.
Thank you so much for those very fascinating insights. I think that it should be very, very helpful and useful for you with regard to learning the role that is required of a law clerk cum research associate. Thank you so much. Thank you so much. We close the session.